name is Volker Kruger from Velden-Duffey, and I'm joined by Thandeka Mpanza from our Labour Law Department to discuss the question whether you can avoid a disciplinary hearing by resigning. I guess the idea of the employee is to make sure that he doesn't have that on his record, and therefore he wants to resign before the disciplinary hearing proceeds, whilst the employer obviously wants to make sure that justice is done, etc. So I think there was a bit of uncertainty previously, Thandeka, before we had this judgment now.
Well, good day, Volker, and good day to the listeners at home. That is indeed correct. We actually found ourselves in a position where we had two conflicting decisions coming out of the Labour Court with regards to this issue. Perhaps let me first make reference to the first matter. We first had the matter of Mtati versus KPMG Services. And in this matter, the Labour Court found that once you have resigned or by giving notice, an employee is entitled to terminate his contract of employment by way of a further unilateral act of resignation during the notice period. What this therefore means is that employees were able to forego serving their notice periods and were thereby able to avoid being subjected to a disciplinary proceedings where they had terminated their employment in such a manner. And then coming out of the very same court, we had another decision. In the matter of Kotsia, the court held that when an employer did not accept an employee's resignation with immediate effect, the employment relationship did not terminate. The court found resignation takes full effect at the end of the notice period, and resigning with immediate effect constituted a breach of the employment contract. The court went on to find that an employer is not bound to accept a resignation with immediate effect and could therefore continue with a disciplinary hearing during the employee's notice period in the employee's absence. And which brings us to the current matter that has now brought clarity to these two conflicting judgments.
So in this case, I think it's the Naidu case, which is a judgment by the High Court of South Africa, Gauteng Division, Pretoria. The facts were also similar to the facts that you just explained in those two cases, and the court basically had to take sides, decide, which of the previous two judgments were correct.
That is indeed so correct, Volker. So in this matter, essentially what happened is that the employees were subject to a disciplinary inquiry after certain allegations of misconduct were leveled against them. However, just before the disciplinary inquiry commenced, the employees tendered their resignation with immediate effect. Now, the employer refused to accept their resignations and sought to hold the employees bound by their notice periods in their employment contracts. The employer was basically relying on the judgment I just spoke of, the Kotsia judgment. And the employer intended to continue with the disciplinary inquiry against the employees even in their absence during their notice period. The employees thereafter approached the court on an urgent basis, seeking an order preventing the employer from subjecting them to a disciplinary hearing.
Okay, and the outcome, what was the finding?
So the court held that resignation with immediate effect terminates the employment relationship. Although the employee is in breach of the employment contract, but in line of this judgment, an employer has no power to discipline an employee after they have resigned with immediate effect. Thus, an employee would need not serve a notice period, and the employer cannot pursue any disciplinary inquiry in these circumstances. However, the court did not leave the employer without any recourse in this instance. The court found that an employer may approach a court for an order of specific performance due to the employment agreement if it wishes to hold an employee bound to the notice period. But so therefore, you would therefore have to approach the court for a specific performance order in that regard prior to you having a disciplinary hearing in the absence of the employee.
Okay. So advice to employers and advice to employees in a circumstance like that?
Yeah, well, the only saving grace, I think, I see that this judgment has been subject to a lot of critique by some academics in a position that it leaves a lot of employers prejudiced, where they would have to pursue other means of going to the High Court to order specific performance, However, the advance that we are glad that there is some clarity as to which avenues employers would find themselves in such a situation. So advice to employers who find themselves in a situation where an employee terminates the agreement with immediate effect is that you can still hold them bound to serving their notice period in terms of your agreement by approaching a high court to order them to specifically perform. In this instance would be to perform out their notice period and to act upon it if there are any issues of misconduct related to their actions, then within that period, then you can continue and hold a disciplinary hearing with them being there present at the workplace.
But why would an employer want to do that if the employee in any event doesn't want to work there anymore?
Because what the effect of this judgment is that essentially an employee would basically, if they are subject, for example, to misconduct charges and they are brought before disciplinary inquiry, they can evade coming to a disciplinary inquiry on the basis that the employer-employee relationship has been terminated. So the only recourse that an employer would have herein is to call them in for the specific performance, have them come serve out their notice period, as to subject them to the disciplinary hearing during the notice period. So it is a bit of a long dry rather to bring the employee here, subject them to a disciplinary hearing, but that's the only recourse that this judgment is giving us currently.
Okay. All right. Thank you, Thandeka.
Thank you, Volker.